Let's take a look, first of all, at the question of what is a corporate record. Well, under Arizona law, Section 10-11601 has a list of documents and has some ideas about how long you have to keep them and who has access. And basically, they are the organizational documents that created your corporation. It starts with the articles, restated articles, or amended articles of incorporation is probably example number one of what is a corporate document. You will also hear that document referred to as a corporate charter. The charter is the same as the articles. You never see charter typed at the top, but you hear people talk about a charter. That's what they mean. Secondly, bylaws, restated bylaws, amended bylaws are the second corporate document and are both these two documents are very important because Arizona's law gives you great discretion in terms of what rights you create for your members. For example, you can start a church and not have statutory members simply by checking the box when you file your articles. If you don't have statutory members, then none of the people who attend the church have the right to take you to court and have a superior court judge review whatever dispute they may be having with you. We have been recommending lately that people form with a church and have scriptural members and define in the articles and bylaws a process which membership means that you've met the scriptural requirements as interpreted by your board and or senior pastor. And with that, if you have a dispute, it will be treated as purely an ecclesiastical matter, and the courts will not intervene. And for many people, the idea that a godless agnostic judge sitting in Maricopa County Superior Court would be in charge of ruling on your problems is not a happy prospect. Rather, they would have their own board of directors or their own denomination or whatever resolve their own internal disputes. Arizona law permits you to do that, but you have to do it in the articles and in the bylaws. If your articles aren't written that way now, they can be amended and you can adopt that form of government. In fact, some major local churches have done just that, and as you reach megachurch status, that becomes increasingly attractive because of the cost of maintaining membership lists, the cost of sending out notice to 5,000 people, and the concept of having a truly worthwhile congregational meeting at which 3,000 people are going to stand up and express their opinion. So as the churches get larger and larger, the function of a member becomes less and less important. In smaller churches, under 100, a different model, the membership idea works well. But as the churches get bigger, it tends not to be such a good idea. Third, official corporate document, any resolution adopted by the board of directors. Excuse me, members of the directors' meetings, also members or the minutes of congregational meetings. Number 5, all written communications to members within the past 3 years. So this would be any official notice that you've sent out to the members of the corporation. A list of the names and business addresses of the current directors and officers, copies of the most recent annual report, and if you have any voting trusts, voting agreements, or other member agreements, which frankly I've never yet seen in a church, that would also be part of the official records, which are defined as the corporate records, which are supposed to be kept at the principal place of business, at its known place of business, or at the office of the statutory agent, most of these for a period of 3 years. Those are the statutory requirements. Now, interestingly enough, the Arizona Corporate Code says if you don't want your members to have access to these materials, you can amend your articles and provide that they're not entitled to them. So by amending the articles and the bylaws, you can literally define what records are going to be made available to the members. So that's an overview of what the corporate code defines as corporate records. But note, it didn't include a lot of things that you might be worried about in terms of confidential information, like lists of donors, how much did they give, employment records, records of the pastor's counseling sessions that are confidential and privileged. So corporate records is one very narrow, specifically defined category of documents, but there's a lot of other information that's maintained inside your corporation that we also have to deal with. So when we speak of disclosing information or producing information, we need to be sure that we're getting into the right category. Any questions on that material so far? And by the way, a reference to the church's constitution, if you look in the Arizona Corporate Code, you won't find the word constitution. We have articles, we have bylaws. If you have bylaws and you have a constitution, the constitution is treated as though it was part of the bylaws. Excuse me, in modern practice, most draftsmen are getting rid of constitutions because they do nothing but offer opportunities for confusion, conflict, contradiction, because I can't tell you the number of document sets I've read where the Constitution contradicts the bylaws, and so you don't know what to follow. And they often set different voting standards, they might set different notice standards. It doesn't really serve any purpose because it's all bylaws. So we recommend you just collapse them into one set of documents, call them bylaws, and be done with it. If you have some specific statement of faith or theological issue you're concerned about, call it a statement of faith, attach it as an exhibit, and then you might set a higher standard for amending or changing it than you do for changing the rest of the bylaws, but it's much less confusing than having constitution and bylaws. So, Monica, does the Internal Revenue Code requirements have any other standards or requirements for disclosing any of those basic documents?
No, they specifically address things like the 990 tax return and other disclosure issues that have to be provided. That information, though, does need to be provided to anyone who asks, so it's not going to be limited by state law.
Okay. So we'll come back to the consideration of disclosure of financial information a little bit later in the program. So at least for the basic corporate records, you can limit your worries to state law. You don't have to worry about the IRS.